Ask Senator Cowser if he'll please open us up with a word of prayer. You are Mike 11.
Thank you, Mr. Chairman. Please join me in prayer. Father, thank you for all the many blessings that you've given us, this wonderful weather and this process that we have developed in this state and this country with all the citizen involvement and the privilege of allowing us legislators to be engaged and involved in trying to make our society better. Thank you for the friendships we have, and thank you for the courtesy and civility that you've allowed us to develop in this committee and in the Senate. In God's name we pray. Amen.
Man, thank you. The sign-up sheet is still sitting up here. Anybody else that wants to sign up to be heard on either bill? All right. We are early in session, and the luxury you have being early in session is we have time. And so we have two bills on the agenda, and I learned last week in putting two bills on, I thought the first one would take 5 minutes, would be done, that sometimes this takes a lot longer than we anticipate. So I want to go ahead and state now, we will have a hard stop time tonight. It'll be when we lose a quorum or by 6 o'clock. And so if we don't get through everyone that signed up to speak, we will have another chance for you to come speak. We're not going to rush anything. If the committee feels like we're ready to move, we can move. Otherwise, we will finish taking testimony at the next time. And I plan to go down the list based on those that have signed up. And once we have to stop, if we get to that point, we'll use the same list the next time we meet. We'll also have a chance for folks to sign up to still speak at the next meeting as well. So I want to go and state that up front just for planning purposes. We will start with Senate Bill 257. I'll ask Senator Anderson if you want to step up. And we are working off of LC 413015. Is that what you have, Senator Anderson?
I do.
And do me a favor before we start. Last committee hearing, only use one. We have to only use mic 1 where Wade is sitting. And so if you want to sit there first, or if you can pull it over, because, okay, do that. Because last hearing I learned as we got going that everybody I had sitting at mic 2, you couldn't hear online. And so we're going to stick with that one mic. So I'm going to leave it hot if y'all just want to share it. So,
Mr. Chairman, there is a Senate substitute.
okay. Hold on 1 second.
My assistant brought it to the office.
Come up here for 1 second. Okay, we do have a substitute, and we are passing it out to the committee members now. It is LC 393121S, and I will ask the author to explain the differences between the substitute and the original bill. Also, we'll start with this. We heard this bill back during our special session at the last committee hearing, though some of the members were not at that, and so I still want you to present the entire bill, and we'll still hear from everybody. But this is something we did have a hearing on before, and I think it would be great, especially with the substitute. You could point out the differences as everybody digests that in their folder now. So now I'll go back and turn it over to you, Senator Anderson.
Thank you, Mr. Chairman, and to my distinguished Senate colleagues. Good afternoon. Senate Bill 257 is an expansion and cleanup to Senate Bill 288. Just a little bit of background. Senate Bill 288 made most misdemeanors and pardon convictions eligible for expungement, which affected or impacted 1.5 million Georgians. Senate Bill 288 created opportunity for employment, housing, and access to higher learning. Senate Bill 288 gained unanimous bipartisan support And with Senate Bill 288 being the launching pad for record restriction, now Senate Bill 257 expands that opportunity to clean up minor issues such as enabling the courts to seal minor offenses, retroactive first offenders petition. It makes expungement automatic for those who have been pardoned, and it allows human trafficking survivors to expunge their records without unnecessary delays. That is it in a nutshell, and I will ask Wade to expound.
You have a lifeline there that wants to walk through some of the aspects of the bill for you
Sure,
as well.
absolutely.
And Wade, you presented at our last hearing. If you'll introduce yourself to the committee, I'll let you go ahead and walk through the bill with us.
That's right. Thank you, Chairman Strickland. My name is Wade Askew. I'm a supervising attorney at Georgia Justice Project. And so you might remember us from SB 288. And so we've been working with Senator Anderson here on SB 257. So first, I'll briefly explain that change made in the substitute in front of you. And then we'll kind of run through all the aspects of the bill. So the one change is represented in lines 21 through 24. So the previous version that y'all saw dealt with nonviolent misdemeanor theft convictions. And so as a little bit of kind of context and background here, SB 288 made misdemeanors, generally speaking, made misdemeanors eligible for restriction and sealing, which is our version in Georgia of what a lot of people refer to as expungement. Under SB 288, there were a couple of versions of misdemeanor theft that were eligible for restriction and sealing, and there were other versions of misdemeanor theft that were not eligible for restriction and sealing. The first version that y'all saw expanded eligibility to two more misdemeanor theft convictions. So if you're tracking here, basically misdemeanor theft was eligible for restriction, but then there was an exception that says some misdemeanor theft is not eligible, then an exception to the exception that says, well, some are. What this version in front of you here today does, what this substitute does, is simplify that and bring consistency to all forms of misdemeanor theft and say misdemeanor theft convictions are eligible for restriction and sealing. Instead of continuing to add exceptions to the exceptions, it brings consistency there. That's what this substitute does in lines 21 through 24. Now, the other provisions of the bill, I'll kind of run through them very quickly. They're, again, small, as Senator Anderson described, small cleanup issues, mostly very technical, but I'll run through them quickly, and I'm happy to take any and all questions. So the second thing the bill does is it makes restriction of eligible offenses automatic for people who have been pardoned by the Board of Pardons and Paroles, as long as that offense is not a serious violent or serious sexual offense. Those are still not eligible for restriction and sealing, even if they are pardoned. The third thing SB 257 does is that it enables courts to seal minor offenses. So there's certain minor offenses that do not appear in the GCIC database. These offenses are already eligible for sealing under SB 288. But current law requires that a record be restricted by GCIC before a court can seal the record. So that creates a problem for these eligible minor offenses that do not appear in GCIC in the first place. And so SB 257 addresses that problem. The fourth thing SB 257 does is it provides a fix for human trafficking survivors who have had their cases vacated under the Survivors First Act. There is currently an unintentional statutory requirement that these survivors have to wait for 2 years before asking a court to restrict and seal their offense. The legislature never intended that waiting period to apply to trafficking survivors, and so SB 257 fixes that problem. Fifth, SB 257 allows retroactive first offender petitions to be filed in court without defendants first having to get a prosecutor's permission to file that petition. So prosecutors can still oppose retroactive first offender relief. They still are entitled to be served a copy of the petition. They can stand up in court and say, we disagree, we don't think this is appropriate, or we don't think this person is eligible for the relief. But petitioners can get into court, and judges have the discretion to make the final decision on those petitions, as they already do today. Last, while criminal justice agencies have always had access to restricted and sealed records for law enforcement or criminal investigation purposes, SB 257 just states this explicitly. We also have a brief amendment from the Prosecuting Attorney's Council that they've introduced an amendment that we believe is a friendly one, and so I'll let Robert Smith from PAC speak to that.
Let's finish y'all's testimony
Okay.
first, and we'll get to him.
So with that, I'm happy to take any and all questions.
Okay, questions from the committee for the author and Mr. Askew. Mike 11, Senator Calzert.
Yes, thank you, Mr. Chairman. There's this provision you went into about after a pardon for an offense.
Mm-hmm.
What happens after the completion of a sentence on a first offender plea?
As it relates
As to restrictability of your record, is that in another subsection not addressed in this bill?
yes.
Is it automatic that it's expunged?
It is not automatic. No.
Why would you automatically expunge it if somebody was sentenced to jail and got pardoned later, but you wouldn't on somebody that was treated under a first offender plea, which would be a less serious offender?
I understand. The thinking is that the actual process for a pardon is a very lengthy and very intensive one. So generally speaking, the pardon process takes about a year with the State Board of Pardons and Paroles. Only about 500 of those are granted, and that happens after investigation, interviews, a very intensive process. And like I said, we have a very relatively small number that are granted each year. And so that's a very, very high bar. There are more first offender cases than there are granted pardons each year. And so the thought is that at the end of that very intensive process, right now, if I'm granted a pardon, then if I want my offense to be restricted and sealed, then I've got to start over, hire an attorney, presumably hire an attorney, file something in court, and go through a very similar process. So the thinking is that if I've already gone through that intensive process with the state board, that I shouldn't have to essentially start over for the restriction and sealing.
Well, but to get a first offender plea, first of all, the prosecutor has to agree. It has to be your first time to commit the offense. So you're not a hardened criminal that's dealing with parole, et cetera. The prosecutor has to agree to it, and the judge has to agree to it. And if you violate the terms of that probation during the terms of your first offender plea, then you have already pled guilty and you can be sentenced to the max.
Mm-hmm.
So these are people that are given a second chance. It seems like they're less egregious criminals that ought to get the benefit of their, conviction or first offender plea being expunged more so than some career criminal that's having to get paroled or pardoned.
Well, so a couple quick things. One would be we'd be very open to explore, further relief for folks who have received the first offender treatment for the reasons that you articulated. For folks who have received a pardon, I first just want to distinguish folks who've received parole will have no automatic relief. They're
Okay.
Folks who receive parole, that they are still in the same situation they have. This has not touched by 257. This only applies to folks who are granted a pardon. And so for those individuals, since that bar to relief is a very, very high one, and the state board would presumably know that this restriction would be going along with their pardon now if this were to pass, we think that that's a high enough bar that gatekeeper is already there. So then introducing a second one is no longer necessary.
Okay. Can I ask one more question, Mr. Chairman? All right, on page 3 up at the top, lines 44 through 46, we can't see the whole statute here on this bill because it's just amending certain portions, but that reads that anybody who is cited for a criminal offense but is not arrested, if the citation is later dismissed or null prost or whatever, then they're expunged. Mm-hmm. What if they're arrested?
So if they are arrested, presumably that case would then appear in GCIC, and so this fix wouldn't be needed for that situation, because what 44 through 46 is ultimately getting at is, again, cases that are already eligible for sealing under SB 288. but the mechanics by which cases are sealed in this state is a two-step process, where first, we have a case in GCIC and we restrict it. Now I've checked that box, the restriction has happened. Now I can go to court and ask for the sealing. And so for folks who, have a non-fingerprintable offense, which are these minor offenses where the arrest never happened, now this didn't appear in GCIC in the first place. And so what some practitioners on the ground have seen is my client is eligible for this relief. They literally cannot get their record restricted because it's not in GCIC in the first place. And so we need a way for the court just to have the statutory authority to do what this person's already eligible for.
Okay. So what I'm sitting here thinking, in Athens, Georgia, our police would more commonly arrest than cite.
Mm-hmm.
That's in the discretion of the officer. They don't have to book in unless they decide to. But ultimately, the prosecutor, under this scenario on a citation, if they dismiss it because they don't have evidence or whatever, then your amendment, it will go off their record. But if they got arrested, even though the outcome is the same, that the prosecutor null-prossed the case or dismissed it, now they're going to have it on their record. Do you object to an amendment to say cited or arrested? It's the same thing. Either way,
Sure.
there are two different ways to charge you with the crime.
Mm-hmm.
And once it's been null-prossed or dismissed, you're letting somebody that was just cited because the jail was full or the cops were lazy or didn't think it was a significant enough offense. Their people get restricted and somebody gets arrested, doesn't, for the exact same offense.
Well, so first we wouldn't, object to the amendment, but the reason why we don't think that's necessarily necessary is because the two people are they're both eligible for sealing. And the person who was arrested, presumably, unless it's a non-eligible offense, but if we're assuming it's an eligible offense, is eligible for restriction and sealing. But because they were arrested, there's now a record in GCIC. So they've got to take care of that with restriction. Whereas a person who was only cited never had a case go to GCIC, so they go straight to sealing. And so currently what the law is two people, same offense, exact situation you just described. The person who's arrested is ultimately able to do restriction and sealing. The person who's only cited is kind of out of luck because there's nothing to restrict. They're eligible for sealing already, but when they go to the court and say, please seal this, the court says, well, we can't because there's nothing, you didn't get restriction first. And then the person just throws their hands up and says, well, I can't get restriction because it's not there. And so the person who's arrested is eligible for restriction and sealing already. They just have to go through the two-step process because the record appeared in GCIC.
So the part of the bill we're talking about just deals with sealing of it. So if they're arrested, it takes more because you have the whole arrest record.
Exactly. You've got to follow the two-step process in that situation.
Okay. Do you have anything else, Senator Calvin?
No.
Any other questions for members of the committee for the author, Mr. Askew? All right, thank you. We
Thank you.
have two other individuals that want to be heard on this bill. First is Mr. Thomas Weaver, who is a private citizen and no stranger to our committee. Step on up. Good afternoon.
Thank you, Mr. Chairman, members of the Senate Judiciary Committee. Like the chair said, private citizen, come down here. My thoughts are my own, don't represent anyone or anything. Just a couple things that I wanted to share with the committee. First, I was grateful to see the substitute version. The substantive changes in the substitute version took care of some of the concerns that I had with the original version that I believe this committee held a hearing on last year during the special called redistricting session. However, there's still one small thing in this bill that's here that remains that I just wonder about. If the committee would be so inclined to underline 69 and 70 of the bill, subsection V, paragraph 1's subparagraph capital G, that language, if you look at the current statute, which is on file with the Secretary of the State, under the most current rendition of the law, the term restrict under Georgia Code Section 35-37, subsection A, paragraph 6, that definition, which is already, if you were to have, like Senator Calstert said, if you were to have the whole thing in front of you, that definition that's already in the law today, I just question the necessity of that, because if you read that definition, it already provides that exception. So it's duplicative. Not that it's a bad thing. I didn't know if it was because of some judicial ruling, maybe an appellate court. I didn't know what the necessity of having it was for putting it there, but I just question if it needs to continue to be part of this bill, since it's already covered under the definition of what restrict is in the first place. And then with that having been shared, the only other thing I'd like to point out is there's another statute on the books. I've shared this with others, Georgia Code Section 17-8-6, which is under a different title of the law that covers what happens in municipal courts, where a lot of the citations, or at least some of them, maybe not all of them, because depending on your county, some might go to a state court, and counties that don't have a state court, some might go to a probate court. But there's another statute on the books that also has play on this too, that the legislature didn't touch, and it's still there. So I wonder to the extent of whether a defendant would be able to find relief there, depending on the particular situation. But not that subtracts from anything that the author's trying to do here. But just wanted to share those two thoughts with the committee. Thank you for allowing me to speak, Mr. Chairman.
Thank you, Mr. Weaver. Any questions for him? All right, thank you. Last person signed up to speak is Robert Smith with the Prosecuting Attorney's Council. And there was reference, Mr. Smith, there was reference to an amendment that had been discussed. I know that's one of the things you'll address in your testimony.
Yes, sir. Thank you, Mr. Chairman. I'll take the first, the amendment. It's a one sentence add to the bill already as it's been presented to you. And what it simply does is it says that if someone wishes to use retroactive first offender, they're not going to be able to use it to knock out or seek relief for a conviction that was used as the basis for a conviction for a possession of a firearm by a convicted felon, or if it was one of the three convictions that were used to enhance or make a defendant a recidivist. The idea is that we've actually seen this happen once or twice, or once specifically, where someone tried to have a conviction that was used to enhance their sentence as a recidivist. They sought to have one of those prior convictions treated as a first offender and then go back and ask for relief sentencing years after the fact. The idea is it promotes finality of judgment, and so people can't keep relitigating cases. And this is a very important tool. It's a very nice benefit to people. We want to protect it and make sure it continues and can be used by people as this legislature and the advocates intend it to be used.
And the committee does not have the amendment. Do you have a copy with you?
No, sir, that's the one copy.
What I'd like for you to do, if you can, is read it and tell us. Yeah, come on up. I'm not a judge. Don't plan to be. If you will tell us, if you will tell us where this needs to go. My understanding is the author doesn't have any objection to this. Okay, she shook her head for the record. Now I sound like a judge. No objection. If you will read the language you have and tell us where in the substitute, if you know that, this needs to go.
I don't have the substitute, but if you find where OCGA 42.866 part D or subparagraph D is being amended, thank you, sir, which right now would be not in, so it'd have to, I guess it would go in. We're amending 42.866 in section 2, so this would be, I guess, line 87, the new line 87. In D,
Line 87.
it'd have to be a new one.
A new, okay, so you're adding to the end in section 2?
Yes, sir.
Okay.
And the sentence simply reads, no relief pursuant to this code section may be given on a conviction that was used as the underlying conviction for a conviction for violating code section 1611-131, or if the conviction was used to enhance a sentence pursuant to code section 1710-7.
And are you saying that would go at in the same section A1 there at the end, starting on line 86 and continue down, or is this a new section?
It's subsection D.
Subsection D.
Same code section is being amended in section 2, but it would be subsection D rather than subsection A.
Does legislative council want to see the language and make sure we're getting this right? Yeah.
I'm sure it's not as artfully and skillfully as written as legislative council can make it sound, but that was the best I could do.
Okay, we have a question. Is it on that point too? Is it maybe a good time to ask it? Okay, Senator Cowser.
So why does this matter to prosecutors if this restriction is only to the general public? I mean, it sounds like, you want to make sure the sentencing judge is aware of a prior conviction so that it can enhance a future penalty. They're going to know that anyway. We're only restricting the public. Prosecutors and judges are going to know that criminal history.
Actually, Senator Cowser, that's not what happens. This is section 2 of the bill, which is the retroactive first offender. This is the section that allows someone who says that when they entered their guilty plea years ago, no one told them that they could seek first offender, and now at this time they can come back and ask for first offender to be granted to them for a conviction that happened years ago. And it's first offender, not record sealing. It's first offender, meaning that if the person successfully completed probation, they shall be discharged without a finding or an adjudication of guilt.
So people are retroactively trying to go back and claim that when they failed to do it at the time?
Yes, sir. If they were eligible,
Okay.
that's the policy and we're supportive of this, giving people a second chance. If they didn't know about it, this is something they should have availed themselves of. So they should be able to go back and say, I would have used my first offender on this conviction. I'd like to do it now, so I have a clean record, so I can get housing, so I can go to school, so I can all the things that are now impediments because of this felony conviction. This legislature has decided to give these people a second chance. They're worthy of it. Give them that chance. Let them avail themselves of the retroactive first offender.
But not restrict it.
No, sir. If somebody successfully completes first offender under the code section, and in theory they would have already have done it. This is a conviction back years ago. They've already successfully completed the terms and conditions of probation. So the process by which they'd go through is they'd file the petition, show everything worked, and then the GCIC would be alerted that this conviction now has been treated as a first offender. It has to be sealed, has to be noted as no adjudication of guilt. They have to be discharged as such, and then the clerk's office seals the record, so no one can have access to it.
Okay. Thank you.
Senator Rhett.
Thank you, Mr. Chairman. I might have missed it, but is there a limitation on how far they can retroactively go back?
I don't believe there is. I'm not for certain, and I'd have to look to my friends from the Georgia Justice Project, but I don't believe there's a limitation to it in terms of time.
All right, do you have more you wanted to say on the bill? Those are all the questions I have right now.
No, other than also to answer a question that Senator Cowser had brought up earlier, that there's been some changes to the First Offender Act that makes the process by which if somebody has successfully completed first offender, I remember they would have to go back and get a petition filed by their attorney, have to go to the judge and be signed off. This body's made some changes to the First Offender Act and made it a little more mechanical and a little bit quicker. There's now a duty and obligation placed on state government agencies that have information to quickly submit that, and once the clerk has it, to give that information to the GCIC so its sealing is a lot quicker. There's not the lag time that there used to be. And that's all the comments I have. I just thank you for the consideration, and thank you also for the opportunity to speak.
Thank you, as always. Any other questions for Mr. Smith before he leaves? All right, thank you. That's everyone that signed up to speak. I want to address the amendment if you're ready, Michael, Legislative Council. Okay, which mic are you? One? Okay. I'll let you tell us what the amendment is, what you propose doing with it. We'll see if there's a desire to move on that.
Thank you, Mr. Chairman. Because this is in kind of bringing some additional substance, it would require amending the title as well and some of the directory language. So do you want me to start at the top?
Sure. Let me do this. Logistically, before we do that, Does anybody else want to be heard on this bill? What's the pleasure of the committee? We have a motion to pass by Senator Jones. Do we have a second? We have a second by Senator Parent. Now we're in position for amendments, so I'll recognize you.
As I understand the amendment, Mr. Chairman, it would read that on line 9, after offender semicolon, you would insert to provide for exceptions to retroactive grants of first offender treatment and discharge, semicolon. Next, on line 82, after subsection A, you would insert and subsection D. And then on line 86, after this article, you would insert, and this was before the period, insert provided, comma, however, comma, that no relief pursuant to this subsection may be given on a conviction that was used as the underlying conviction for a conviction for violating Code Section 1611-131, or if the conviction was used to enhance a sentence pursuant to Code Section 1710-7.
All right. Is everybody clear on the amendment? Obviously, there's multiple parts because you're going to put this in place in the bill. Is there any questions for Ledge Counsel on the proposed amendment? If not, does anybody want to offer that amendment from the committee? Senator Jones offered the amendment as stated by Ledge Counsel. Is there a second? Second by Senator Parent. Any discussion on the amendment? All in favor of the amendment, please raise your hand. It passes unanimously. So the bill has now been amended. So we're working off a motion to pass LC 393121S as amended. Any other? 1 second. I love people that keep me straight. So we have to report this out as another LC number that'll be to be determined at this point, if that's what the committee desires to do. And so we'll have a new LC number added to this for this bill as amended. Is that clear? Is that good? By substitute. By substitute. Is everybody clear on what we're about to vote on? Any further amendments? Any further discussion? All in favor of the motion, please raise your hand. It carries unanimously. Hopefully we did it right. All right. Thank you, Senator Anderson. Appreciate your work. You're on to rules.
Thank you, Mr. Chairman, and the members of the committee for your support on this life-changing bill for Georgia.
Thank you. All right, we will go to the next bill on our agenda, which is Senate Bill 319. Senator Anavitarte, if you want to come up. We are working off the original bill, is that correct?
Good afternoon. I believe so, Mr. Chairman.
Before we get started, are you working off the original bill?
Yes,
and
sir.
so you're working off LC. Let me get to it. LC 280017, is that correct?
Yes, Mr. Chairman.
All right, well, the floor is yours.
Thank you, Mr. Chairman, fellow colleagues. Good afternoon. Here to present Senate Bill 319, and just short presentation, but I do have some comments So this idea, I don't think it's probably new to anybody, whether you're for or against constitutional carry in the state of Georgia, but came to me from constituents in my district. I represent 3 counties in West Georgia. And so I come to you not as an attorney. I'm not going to sit here as an expert necessarily on the Second Amendment or a statistician, but basically to represent the constituents of my district in West Georgia. The Constitutional Carry Act, which is Senate Bill 319, basically touches on the inherent Second Amendment right for an individual to carry a weapon without a license in the state of Georgia. It authorizes lawful weapon carriers to possess a firearm in all places in Georgia law allows currently without a license. It does not change any restrictions or requirements already in place for someone to purchase or own a firearm. And I know that's going to be a discussion that we're going to hear from a lot of different groups and potentially leaders and organizations. But I want to state it again just so it's very clear, it's clear and everybody understands that this bill does not change any restrictions or requirements already in place for someone to purchase or own a firearm under the current law in Georgia. I just want to run through a few facts on constitutional carry in Senate Bill 319. Permitless carry simply allows a person who is otherwise legally able to possess and carry a firearm to do so. Permitless carry does not change any prohibited person, laws, or any law governing the misuse of a firearm in prohibited places where a firearm cannot be carried or when force may be used in self-defense or others. The requirement to have a permit does not deter nor disincentivize a criminal from carrying a firearm concealed. They will do it regardless. Permitless carry gives criminals a reason to fear that any potential victim could be armed and thus disincentivizes criminals from conduct. Basically, in short, I know there's going to be discussion that this law has the potential to just put all sorts of new guns and weapons on the streets, and I'll tell you that's patently false. In addition, this bill will also allow Georgia to retain concealed carry permitting process for gun owners who wish to take advantage of concealed carry reciprocity in other states. I think we'll also see that in other states, like the state of Idaho and others, that even though the permit laws may be changed or have been changed, that there was still a steady rate in which citizens went to basically request and went through and filed to get a license in those states. So I don't expect that to change very much also. 21 states across the country have enacted constitutional carry for permitless carry. Of those 21 states, Alaska, Arizona, Wyoming, Kansas, Maine, Idaho, West Virginia, Mississippi, Missouri, New Hampshire, and North Dakota enacted permitless carry between 2003 and 2017, and are states from which there is ample data to analyze the aftermath of that. Vermont, as many knows, has had constitutional carry for over 200 years. In overwhelming majority of these states, firearm-related crime has either decreased or remained relatively flat based on FBI data that we have seen. Only 6 states require a safety training program to obtain a license. In those states, the other 44 do not. According to the U.S. News and World Report, Maine, New Hampshire, and Vermont are three of the top 4 safest states in the country when it comes to violent crime. All 3 states have constitutional carry laws in the nation. In conclusion, constitutional carry provides law-abiding gun owners the ability to exercise their constitutional rights under the Second Amendment, which clearly states the right to keep and bear arms shall not be infringed, end quote. Data also shows that overwhelming majority of cases in states have enacted constitutional carry laws have seen decreases or negligible movement in firearm-related crimes, and the bill puts the law-abiding legal gun owners on a level playing field with criminals to make our communities more safe. If we want to deter crime and take the weapons out of the bad guys and gang members and those committing crimes, then we should invest in law enforcement in this state. So with that, Mr. Chairman, I yield back to you.
A couple questions. If somebody still wants to go through the process and get a concealed carry permit, does your bill eliminate that process?
No, Mr. Chairman.
Is there other reasons people would still want to get a permit even under your bill?
From talking to most of my constituents, the main reason why it would be a reciprocity to take the weapon into other states that would recognize that.
And your bill is lengthy when someone just looks at it. But I want to be clear, another question, is there any part of your bill that expands who can currently possess a firearm in our state?
No, this bill does not do that. The only two things this bill basically does is address the license question, permitless carry, and the reciprocity question.
Does
This
your
does-
bill,
Go ahead, Mr. Chairman.
well, does your bill have any impact on where a gun can be carried in our state?
No, this bill does not address private property rights or any of those concerns.
Okay. Questions from the committee? Start with Senator Parrott.
Thank you, Mr. Chairman. Thank you, Senator. I have a few questions. Are you aware that in 2020, according to the Council of Probate Court Judges of Georgia, at least 5,000 people were denied weapons carry licenses? And this is actually a figure that's low because it's voluntary reporting, so not every county reports. You're aware of that? And are you aware that the number one reason for the denial is criminal history?
It probably would make sense if we're doing background checks and those judges and other entities are doing their job, then there are going to be people who are going to probably be denied a license.
So your bill would eliminate that. So why would we want to make it easier for
Well,
these
to
criminals
purchase-
to carry a gun in public?
To purchase a weapon, the background checks and all those things are going to still be in existence. So we can have a discussion about, where are people getting guns, or how they're obtaining them. I think I can tell personal stories of my brother was in a gang and the things we experienced growing up in DeKalb County, Georgia. And I think the sources of where people get their weapons. But at the end of the day, I think if we want to stop that and we want to stop the bad guys from getting guns, then we need to make those investments in cracking down on criminals.
So you're saying that for the 5,000 people, which is a low number, that are criminals that were not given a weapons carry license last year, that doesn't concern you at all, that that check would just disappear?
I think through the background check process, when you try to purchase a weapon, if you're breaking the law and you're not supposed to have a weapon under current Georgia law, you're going to be found.
So, but in Georgia, we don't have universal background checks, correct?
Correct.
So then how does that, the point you just made is there is a check because of background checks, but we don't have that in Georgia. So can you explain
Yeah, this
why
is-
you think that's safe?
Yeah, I think Georgia's going to be safe because if you're a law-abiding citizen and you're carrying a weapon, I think it's going to be okay. I think if we're talking about, this isn't going to have any sort of impact on, we're going to keep the guns away from criminals through this bill. And I don't think that's a concern. I think we're here, and I'm here on behalf of my constituents, basically talking about the inherent Second Amendment right that I think we have to have not have government barriers, not have government bureaucracy, other extra layers and steps that basically infringes on that right.
So if we're granting the 5,000 and others, there is no check anymore. I'm not sure I follow your rationale, but the question that now occurs to me is, given that we would eliminate this check and we don't have universal background checks, what is the enforcement mechanism to prevent felons and domestic abusers from carrying a gun?
The checks that are in place, I mean, just like when you go to a store and you want to purchase a weapon, you're going to have a background check done on you.
But what about all the places where you don't? Because
I
there
don't
any
think-
private gun sale,
Yeah.
sale or gun don't have any of that.
Well, I don't know that we're going to, I mean, the same situation could play out too if we're going to talk about the transfer and sale or, whatever of weapons between one gang and another on the street. So, I mean, do we have a solution for that right now? Because I think the solution is, once again, is making those investments to crack down on those individuals.
I'd be happy to work with you on solutions. Can I
let's do
ask
it.
a couple more questions? Thank you. So evidence from other states, in fact, is alarming. Alaska was the first state to do permitless carry, and and that was in '03, and they experienced a 65% increase in aggravated assaults with a gun. Arizona did it in 2010. Annual rate of aggravated assaults increased by 8%. Those don't, I mean, the evidence in front of us and all the data from other states suggests that more guns in more places leads to more violence, more death, and more accidents.
Yeah,
Let's stick with questions. At least say, isn't it true? Make
Yeah.
it seem
Isn't
like
it
a
true?
question.
Yes,
Thank you.
isn't it
And
true?
let's try to stick
Thank
with
you, Mr.
questions.
Chairman.
There'll
Isn't
be,
it true?
There'll be a time for us
I
to
thought I
debate
did.
the
I thought
issue.
I did that.
No, you
Sorry.
messed it up.
Okay, I did. Thank you.
You did,
I messed it
Senator.
up.
To my friend from DeKalb, I'll give her that one. No, I would
thank you.
respectfully disagree.
Okay. Well, there's facts and data and statistics,
Yep.
and frankly, those aren't open to. I disagree.
Right.
One more, Mr. Chairman. Have you heard of Grayson Fleming Gray and Matthew Wilson?
No.
So just in the
don't think
last
so.
couple days, in fact, there have been a lot of tragic incidents just in the last couple days. Grayson Fleming Gray is the 6-month-old baby who was riding in his car seat and died. Matthew Wilson is a British national who was visiting his girlfriend in Brookhaven and was in an apartment and died from a stray bullet. How would this legislation, which removes a check on criminals getting guns and being lawfully able to carry them, help these people who are dying every day from random stray bullets?
So, first, I'm not familiar with those two incidents. I mean, I will like to talk to you offline about those specific incidents. When it comes to stray bullets, I mean, I grew up in a community and neighborhood where, you know, many circumstances, stray bullets would fly every single day. And whether it's people thinking they're celebrating, trying to be cute, shooting weapons straight into the sky, and they're coming back down into roofs of homes and daycare centers or whatever the situation is, all those things should be taken seriously. And whether you're an individual who wants to be careless with a weapon, or you want to be an individual who should not have a weapon, I don't know that removing a license for somebody to obtain a weapon lawfully, a law-abiding person, wouldn't necessarily change that situation without knowing the facts of those two situations.
Thank you.
Senator Rhett.
Thank you, Mr. Chairman. Will the senator yield? Excuse me. I'm sorry.
You gonna ask questions?
Yes, I do. Just a quick question.
Yes, sir.
Have you had a chance to discuss this bill with law enforcement? And if so, what has been their feedback in terms of this legislation you're proposing?
Thank you, Senator. I have discussed this, I know, with my local law enforcement. My law enforcement in our community supports it. I've heard from other sheriffs around the state who have supported, or other local law enforcement folks.
Have you talked with anybody from the Atlanta PD or the Metro PD and engaged their thoughts on the matter?
No, not as of yet. But if they want to
Wasn't
talk
that-
about it, I'd be more than willing to.
Wasn't that where the people you were talking about had that situation? Okay.
It wasn't one.
Thank you.
There was reference to 5,000, I think was the number you used, people that were denied.
2020, it was, I can pull it up, but 2020 was like a little over 5,000.
Do you know, Senator Ambatarte, how many licenses were approved in the state in 2020? Do you have that information?
No, we were not able to obtain that data yet before today.
For those, if it is 5,000, going with the number it was given, for those 5,000, if they are denied a permit, is there any further action that's taken from the state or anybody else to keep them from carrying a gun still?
Say the question one more time.
If we go with the 5,000 number, someone is denied a permit, is there anything done by the probate courts or anybody else dealing with permits that keeps those 5,000 people from having a gun in their possession? Is there anything being done to stop that?
If there is, I can't say that I'm fully aware that that's taking place. I know in our community that's not been a discussion point.
And under your bill, again, those 5,000, can they legally now carry a concealed carry? Can they carry a weapon concealed in our state under your bill?
No.
Who's Mike 11? Senator Cowles, I should know by now.
Senator, in the definitions of lawful weapons carrier that you keep going back to here, it says any person who is not prohibited by law from possession of weapon. Now, I know convicted felons in Georgia are prohibited by law from possessing a weapon. What other Georgia laws are you aware of that prohibit citizens from possessing a weapon?
I think, as I mentioned before, I won't sit here and pretend to be an attorney, but I think, as far as I'm aware, with the way we've written this bill, we're not tinkering with, I think expanding on kind of, I think, your question in terms of, are there other areas where somebody could, carry a concealed weapon? So
This is just possession.
this is only
Concealed weapons carriers are out after we pass this bill, but
right.
but this allows anybody that's not prohibited by law from possessing a weapon,
Right.
to do it.
Correct.
Constitutional carry. I just wondered what other Georgia laws might prohibit the possession of a firearm.
I think if you're bottom line, you're breaking the law and you're a felon, or you've done something pretty bad, those laws are going to kick in and prevent you. So this law is not going to override or change or none of that, anything like that.
Okay, thank you.
Thank you.
Senator Jones?
Oh, thank you, Mr. Chairman. I just have a few questions, really, because I get confused about all of this, quite frankly. So, number one would be, you had mentioned in your opening that you have a right to bear arms and should not be infringed upon. So does this law infringe upon a person's rights at all to bear arms or carry? Is there any infringements in this particular law?
Under the current law or the
Even your
proposed
bill,
law?
current and what you're not changing?
I think what we're changing is to remove the infringement of the Second Amendment,
What would that infringement be?
to have a government barrier or something to carry a weapon.
So there are no barriers at all within current law or this law about carrying?
License is the barrier under the Second Amendment that we are trying to address.
So are there barriers such as when you go into government buildings and things of that nature?
I mean, depending on what you want to describe, like a metal detector and other barriers such as that, or
So there are barriers.
if you want to call that a barrier, but that's not an inherent barrier on the Second Amendment.
Well, it would stop you from carrying into those particular
Well,
places, correct?
Well, some of those places are also private property, and I think there's laws that probably talk about.
Well, but there are barriers. So my question becomes, if there are barriers, which you're conceding that they are, what's so bad about having to have a permit?
But those aren't barriers that are being afforded by the Second Amendment. Those are basically private property rights barriers, I think, that are discussed in other parts of the law.
But there are many exceptions that go beyond the private property that you mentioned. Is that not right? That create barriers to carrying.
I mean, there's barriers, but there's also the Second Amendment. I think the Second Amendment is very clear on what it says.
I want to look at, if I can, Mr. Chair, page 10, line 238. It says a person who is not a lawful weapons carrier and who attempts to enter a government building carrying a weapon shall be guilty of a misdemeanor. How would you know if they're a lawful weapons carrier?
Yeah, I mean, are they a criminal?
How would you know they're a criminal?
How do I know whether my next door neighbor is a criminal?
I'm asking about this particular situation.
I would apply the same situation. I think in that situation, I don't know if somebody's walking down the street carrying a weapon as a criminal, or as I was growing up, my next door neighbor, whether they were carrying weapons and moving contraband for thugs and other elements in our neighborhood.
But this is not about your next door neighbor. This specifically says within this bill that a person who is not a lawful weapons carrier and who attempts to enter a government building carrying a weapon shall be guilty of a misdemeanor, which is a crime. So it's serious. I mean, we're convicting someone of a crime, and a misdemeanor you can get jail time. And so I'm asking is, how would we know that they're not a lawful weapons carrier?
I think that the same as any other situation or citizen we may place ourselves in. We may I think, whether we want to use a government building and security apparatus and those things, those are all investments to keep ourselves safe.
But this is not a security apparatus. This says that they're not a lawful weapons carrier. What makes a person a lawful weapons carrier?
I think having a clean record and staying out of trouble and haven't been locked up for breaking the law.
But how do we know they have a clean record?
Again, I'll go back to my example before. How do we know a person walking down the street or in our neighborhood or who lives next door to us has the same situation?
So we do know, is it not correct, as far as like being a lawful weapons carrier, you can't be a felon, correct?
Correct.
Can't be, I believe, convicted of domestic violence, and can't be a first offender on felony probation. I think that's 3 of them, correct?
Right.
All of those are backed up by paperwork, right?
Right.
So one way we would determine that you're a lawful weapons carrier is to say, can I see some sort of paperwork? There's no other way. Is that not right?
I mean, if we want to check papers of somebody who walks in the door every time they walk in the door, Senator, I guess that's the case.
Well, that's what this says. It says if you're not a lawful weapons carrier, you're going to be convicted of a misdemeanor. And I'm asking, how would we know that other than asking for someone's paperwork?
I think that's for every local government or private property owner to determine for themselves.
So if we ask for their paperwork, what would be wrong with asking for a permit?
Again, I think that's up to every property owner to determine for themselves.
But this isn't a property owner, is it not? It's a government building.
Well, I think the leaders of that local government or whatever the case may be, but we're here dealing with a bill that's talking about the Second Amendment and removing a government barrier in terms of the license to obtain that in regards to the Second Amendment.
So would this particular part of the section basically give them the right to ask for paperwork? How else would they know that they're a lawful weapons carrier? Because the difference is if you have a permit, and that's the paperwork, I can say, you're walking in with the weapon, can I see your permit? Because there had to be a permit. Now it says you have to be a lawful weapons carrier. It's backed up by paperwork, but you don't know it by looking at someone, whether they're a felon or they have a DV. So does a government actor get to say, I want to see your paperwork?
Senator, I hope not. I've never walked in a government building in my entire life and been asked for paperwork whether I was carrying a weapon.
How would this provision be enforced then?
Which
This
under your
provision right
example,
here.
or
It's not my example, it's in the bill. How would it be enforced?
I think if we're going to randomly ask for paperwork for different individuals or people coming and going out of buildings, I mean, I think that's up to a government entity to kind of figure out.
Senator Hatchett.
Senator Vitarte, I appreciate you bringing this bill. And to address the previous question, as lawmakers, we make the law, and is it your understanding that we allow the law enforcers to enforce the laws as they're written?
That's correct.
Right now, if you are a felon and you have a warrant and you get pulled over for speeding, and a police officer takes your driver's license and runs it, how would he know that you're a felon?
He's going to have to run it through a criminal database to see if you have what's on your background check after he's running your driver's license.
And right
GCIC.
now, we're in a state building. If you don't have a badge like we have, it's my understanding you have to show your ID to even get into this
Correct.
building. If I were to carry a weapon into this, attempt to bring a weapon into the state building or any government building, most government buildings have guards. If you were to be stopped or caught with a weapon, would it be feasible for the security guard or police officer in that facility to ask for your ID? And at which point, number one, if they knew you were a felon, or if they had some type of mechanism in which they could use their radio to call in your ID number, would they then be alerted to know whether or not you're a lawful weapons carrier by knowing if you're a convicted felon or charged of some of these other crimes that would prevent you from being a lawful weapons carrier?
Yeah, I mean that's true, and I think also too, I think the training that law enforcement goes through to handle those situations, whether somebody is stopped in the car, on the street, in a government building, I think all those situations apply. But yes, it all usually typically goes back to, you having some sort of photo ID or some sort of.
And isn't it true that there are other reasons why you would not be characterized as a lawful gun carrier. Like, for instance, if you're high on methamphetamines or you're intoxicated, extremely intoxicated, visibly intoxicated, that you're not allowed to carry publicly. Is that your understanding?
Yes, sir.
Which, if an officer were to recognize that, you would then be a someone who's not legally allowed to carry.
Correct.
Thank you.
Thank you.
Does the current law allow law enforcement or security at, for example, a government building, as was pointed out, to stop somebody and ask them for their concealed carry permit?
I'm not aware of that. If that is the case, then you can educate me here.
I don't believe it does. I think the law says they can't stop you and ask you for your concealed carry permit. So I guess my question would be, what's the difference whether you have a permit or not? How else are they going to find out whether you're a lawful gun owner?
Well, I agree with that, Mr. Chairman. I mean, unless we're going to just randomly stop people, I think, from coming and going, I think that potentially could create a whole nother set of issues or judicial issues in those situations.
So your understanding is a concealed carry permit as it exists in the law really have any benefit for security or for police when it comes to people entering something like a government
I
building?
believe law enforcement and the government officials, and we're going to use the example of a government building, they're going to have their protocols and security plans and those things already in place. So this law is not going to change or inhibit anything that they're currently doing. And I know that for many of our leaders in law enforcement and public safety of what they're doing, I mean, I think every day they're striving to enhance and create even better plans than what maybe they've had in the past. So this law isn't going to change any of that.
And if a government building has security set up, no one can come in with a gun, whether you have a concealed carry permit or under your bill. You still couldn't carry a gun inside, correct? If there's
Correct.
security there. Senator Tillery?
Thank you, Mr. Chairman. Senator, do the folks who break the law care if we have a law that says they need a gun permit?
No, most lawless people, and I know from growing up hanging around some pretty bad element and, being around my brother, those individuals don't care about laws or anything.
So is it your premise then that the folks who are burdened by this process are actually those who are obeying the law?
Correct.
Okay.
Yes, Senator.
Senator Parent?
Thank you. Senator Innovatore, a couple other questions. So it's my understanding that under our current law, you can have a weapon at age 18, but you can't carry it publicly until you're 21. What will the enforcement mechanism of that be if we pass this bill?
I think this bill isn't going to change any of that. I mean,
But if you don't have to have a permit, then it does, because there's no way to enforce the law.
Senator, all I'm going to say to that is, because I think we're caught up on, what are we going to enforce once this bill passes? Other than striking the word license in the law, we're not changing the enforcement of anything else that exists. So if a local government, a local police department, sheriff's department, or whatever, whether it's related to, government property and they feel like, they have a security plan and maybe it's not as good it needs to be, as well as it needs to be, then I'm sure there's going to be enhancements they're going to do. But this isn't changing any other code sections. This isn't changing what we would normally do. And I think in the other 21 states that have passed constitutional carry, we've seen pretty much almost no changes or effect in terms of what's happening in those states. So I think to lead on or make people believe that this is going to create some sort of change, I think kind of where you're leading of people getting more guns or facilities becoming more safe, and those kinds of stereotypical examples, I think it's just blatant, it's just patently false.
Well, as we already discussed, actually, it's well documented that it does lead to more gun violence. But my question I have
I
for
have my facts. That's fair.
No. So OCGA 1611-106 provides for stricter penalties for possession of a firearm during a commission of a felony. Why do we have that law?
I'm not an attorney, Senator.
Might it be because a fair inference might be that the rationale behind that is that having a firearm during the commission of a felony makes it more likely to turn violent?
I've not read that. I don't have that code section in front of me. I'm not an attorney, so.
Well, then you could take my
I'll
word
take
for
your
it.
word for it,
Thank
Senator.
you. Yeah. So would that be a fair inference that that's why we have that law on the books?
Senator, if that's the case, I'll go with you on that one.
Okay. So would you then also agree, thank you, that guns intensify violent encounters as that law, that code section 1611-106 is predicated on, upping the stakes and worsening the outcomes, which explains why there are more deaths and life-threatening injuries where firearms are common?
Well, I don't think that's guns. I think that's people and people not handling guns properly, or people who should not have guns not handling them properly.
So if you agree that certain people shouldn't have guns, why are you presenting a bill that would remove one of the very small checks we have in a statewide system of incredibly lax gun laws, where we enable criminals and other people that should not have them to have them? And that's led to, for example, 6 woundings and injuries of children in Metro Atlanta just this month.
Well, the only thing I'll say is I don't know that Georgia has lax gun laws. I think that's probably in the eye of the beholder.
No.
But, I mean, the folks that I'm talking about would be gangbangers, repeat offenders, drug traffickers, some pretty bad folks, and maybe even some lesser bad folks that have them. I think if we're going to talk about, crime, we're going to talk about, shootings in neighborhoods, things that, I've know people who've either experienced that or been around it. I don't know if you have, but in many cases, we're talking about neighborhoods where maybe police isn't present, investments aren't present, and I think if we're going to have a debate of, we want more, safer communities and less gun violence, then I think as state leaders and even local leaders, and I've told groups this even more recently as we talk about, local communities going through their 2020 budget processes, then make the investments into law enforcement and support public safety. And then, also too, what are we doing in terms of policing in neighborhoods and communities at that level? I think is the real debate and discussion that I think you're touching on.
Well, and I just have one more, if you'll indulge me. I mean,
Yes, ma'am.
There have been plenty of bills filed every year that would help the situation that you just discussed. But that's my comment. The question is, are you aware that for any time any weapon is used to deter a crime, 8 other crimes are committed? So it doesn't help end any gang banging to give all kinds of people guns. Are you aware of that?
I think your view and my view, I think it's a different interpretation. As someone who has served as a local elected official, who has actually built and funded a local police department, formerly in DeKalb County, I will tell you that I think those investments were the greatest deterrents to gun violence, and seeing the rise of human trafficking, gangbangers, and other elements that we've seen in neighborhoods. And I will attest too that those communities who didn't make those investments during my time in the early 2000s around us probably saw a higher rate of those incidents that I think you're describing happening in local communities. So I think at the end of the day, I can't speak to what bills came before me or what leaders did before me. All I can do is speak to the legislation in front of me and what I'm going to do the next day. But in terms of my record, I think it's pretty clear where I stand and what I've done in my career.
Well, Senator, I have no problem with making proper investments in law enforcement. That's, of course, important. But what laws we have on the books matter, and that's why law enforcement has been, in many ways, very against all the loosening of gun laws that has happened in this state. And this is another example. Law enforcement, I've got plenty of quotes right here from Georgia law enforcement officials. The Atlanta police chief just said, the proliferation of weaponry that we are seeing on these streets, we have to do something about it. So I would say if we were going to, isn't it true that if we were going to support law enforcement, we would listen to what they have to say and work on those problems that you are eliciting, that you're elucidating, and that I'm agreeing on, and that your bill does nothing of the sort?
Well, I would also argue, too, that if we're going to talk about the city of Atlanta, that we make the investments necessary to support law enforcement and public safety in the city of Atlanta so neighborhoods don't feel like they're being not patrolled or otherwise where gun violence is happening.
Thank you.
Thank you.
Senator Rett.
Thank you, Mr. Chairman. Senator Jones might have addressed this, but you know, I'm just an old boy from Marietta, Georgia, so I'm going to ask it in layman's terms. It says that, you know, it authorizes lawful weapon carriers to possess a firearm in all places. Does that include or exclude the state capitol and schools? And if it exclude them, is there any particular reason why?
No, again, I'll repeat it. This doesn't change the laws of how we do business currently, or anything.
Senator Jones.
Okay. So I have a question. Can you currently carry a handgun in public if it's visible under Georgia law?
Can you state again,
Currently
Senator?
carry a handgun if it's visible in public?
Yeah, I mean, I've walked around Hiram, Georgia, at the Home Depot, and I've seen long guns and I've seen other weapons on people's in their holster.
So this would just allow you to be able to do it, concealing it.
But the only thing this bill does is not require you to get a license.
Would you be able to conceal then the weapon? Is what I'm asking.
I'm
without a license. Do you need let me ask this. Do you need a license now to carry the weapon openly?
Long guns, and it depends.
On what?
I think like I said, I'm not going to sit here and pretend to be a Second Amendment expert. I think it depends on a long gun. You can. I've seen weapons.
Okay. All right.
All right. Senator Tillery.
Thank you, Mr. Chairman. Senator Anavitarte, haven't we seen a spike in the number of concealed carry weapons permits lately in Georgia?
Probably so.
And do you think that it's likely tied to the fact that people don't feel safe?
I think safety is a major state, national, even local discussion, Senator.
And would you agree with me then that the people who are going and getting these permits, it's probably law-abiding citizens, right? They don't have gang sign-up day to go get your concealed carry permit, do they?
No, if they do, I'm sure law enforcement is tracking them and going to lock them up.
In that case, then, wouldn't this barrier only be, again, to law-abiding citizens?
Yes, I think that is all we're talking about, and I think the what ifs and everything else, I don't think I can sit here or any of y'all can sit here and predict what's going to happen in the future. If we look at the data and we want to look at the facts of what has happened to permitless carry in other states, crime rates and incidents have either remained stable or have decreased.
Thank you.
You're welcome. Thank you.
How many other bills do you have in Judiciary right now, Senator?
3, Mr. Chairman, I believe, and counting.
Do you still want hearings on those as well?
I'm just a kid from DeKalb County, Georgia Tech.
Don't play
I'm not an
play
attorney.
the kid. Okay. You have no other questions. Run before somebody pushes a button.
It's all right.
We have people signed up to speak. Obviously, sit tight in case we have more questions for you. I'm going to go down the list and start with Aaron Darr with Georgia Gun Owners. We are trying our best. We're all adults in the room. We're trying our best to limit testimony to 2 minutes. So we're going to have a timer. If it goes off, we'll turn it off. Just try to obviously finish your thoughts. 2 minutes does go quickly, but just so we can try to get through everybody. And so you'll hear a timer and just try to wrap up if you're still going at that point.
Well, I think you hashed it out pretty good, Mr. Chairman, so I'll be brief. Again, thank you for your time, all the members of the committee. My name is Aaron Dorr. I'm here on behalf of the members of Georgia Gun Owners. We've been pushing this bill for a long time here in Georgia, and our members are fully in support of this legislation, SB 319, known as constitutional carry in Georgia. We've already discussed this a lot today. I'm not going to belabor a lot of the points, but this bill is really simple. We're not addressing who can buy a gun. We're not addressing or making it any easier for a criminal to access a firearm. We're not getting rid of or in any way changing the current shall issue system here in Georgia. And it's not going to lead to an increase in crime either. All this bill does is simply says that law-abiding citizens who already can legally possess a firearm can carry that firearm with no need for additional government paperwork, restrictions, fees, or anything else. That is the nutshell of this bill. And anybody who says that we're going to see a spike in crime is not dealing with the reality of the 21 states, almost half the country, that has already enacted this legislation. We've heard some stats here today about certain types of crimes that have gone up. I can't speak to every example given, but the reality is that murder in every state that has enacted constitutional carry has either remained the same or gone down. In many cases, if not every case, rape also has either remained the same or gone down. So you might find one area of criminal statute that may have seen an increase that's probably not even tied to this bill in the first place, but the reality is that crime rates have stayed the same or gone down in the states that have done this. At the end of the day, for the members of Georgia gun owners, this bill is not really even about policy anymore. Criminals are going to have guns. They already do. Good guys have guns. We already do. This is about freedom, and it's about law-abiding Georgians not having to put their name in a government database, being tracked by their own government just to exercise a Second Amendment right. We've waited a long time for this bill. We'd love to see it happen this year and encourage this committee to move it through committee as soon as possible. I'm answer any questions you may have.
Thank you, Mr. Dorr. Any questions for him from the committee? Obviously, your 2 minutes won't be counted for questions. Senator Parent.
Thank you.
Yes, ma'am.
I have 2 questions for you. Did your organization take the position in 2014 that a bill passed then that very much broadened gun access in Georgia would also not lead to an increase in gun crime?
I wasn't involved with Georgia Guns at that time. I wasn't involved with that bill. Our push has been for constitutional carry the entire time.
Would you agree with me that we've seen a vast increase, a serious increase in gun crime and gun violence since 2014
especially
in Georgia?
especially in all the blue cities where the laws are very much geared towards protecting criminals in many cases, yes.
We've seen it, but wasn't the claim that you just made and that was made in 2014 is that all that would be eliminated due to more people having guns?
Well, we were not involved with that bill at that time, but every study that's ever been produced has shown that more guns leads to lower crime rates.
I have 5 on my desk right now that show the opposite. And
were they Bloomberg funded studies?
No, they were not.
Let's talk one at a time.
Okay, well, I'll move on.
Hold on.
Excuse me.
Hold on.
I apologize for interrupting.
I think you'd asked a question. I don't remember what it was, but you'll finish answering the last question that she asked, then I'll let her ask another question.
If you could back up, I've lost track.
Let's start over.
Asking
her question. How about
mine
that?
is just a comment. I mean, I really take issue with the widespread manufacturing of statements that more guns lead to less crime, and that's just I really take offense at that. The question I have is, so would you likewise regard it as burdensome that people have to get a driver's license and take a test to be able to operate a vehicle?
Well, the difference is there's no constitutional right given to us by our founding fathers to drive a car, and how we operate and travel. Our right to keep and bear arms is constitutionally guaranteed.
Isn't it the case that no right is absolute?
I'd not agree with that when it comes to the Second Amendment.
So it's totally fine with you and people, because under the law, the courts have never held that a permit license was not constitutional under. No federal court has held that under the Second Amendment. On the other side of the coin, plenty of courts have routinely held that our First Amendment rights, our Second Amendment rights, can be curtailed in the interest of safety of others. The classic example being you're not allowed to scream bomb in a crowded theater or in a crowded airport. Do you disagree with that jurisprudence?
Well, first of all, there are Supreme Court cases that are pending right now to address the constitutionality of the permit process at the federal level, at the Supreme Court level, So we'll see what happens with the courts in that process. But every type of infringement that you're talking about, as has been said by this committee previously, only impacts the good guys, because the criminals don't care about the laws that we pass. The criminals just don't care about your gun-free zone policies or whatever it is. They're going to carry regardless. The current infringements only impact our members and other law-abiding Georgians.
Well, I disagree with that, but the question I have is, so you do or don't have a problem with the limitation on the First Amendment of screaming bomb in a crowded theater?
I'm here to speak about constitutional carry. I can't get into the First Amendment. It's not my area
It would
of
sound to me
expertise.
that, isn't it true that you don't really think that should be struck down? And so I would posit to you that all constitutional rights have reasonable limitations in the interest of safety of others.
I'm not sure if there was a question I have to answer, Mr. Chairman, or what that was.
Isn't it true?
Isn't which part true?
What I just said.
No, we do not agree with any limitations on our right to keep and bear arms. These are constitutionally
What about- I'm asking
guaranteed
about-
freedoms.
Hold on,
First
hold
Amendment.
on. We can debate the Second Amendment. Let's at least stick with the first one, okay? Let's talk one at a time. Please finish whatever your answer to that last question is, or I'll move on.
I'm free to move on.
Okay. Any other questions? All right, thank you. The next person up to speak is Bethany Young with the National Association for Gun Rights. Good evening.
Good evening. Thank you, members of the committee. My name is Bethany Young, and I represent the over 4.5 million members of the National Association for Gun Rights, which includes thousands of gun owners across the state of Texas. Sorry, I'm from Texas now, but I lived in Georgia my whole life until a few years ago. Across thousands of gun owners across the state of Georgia. We were very happy to see Senate Bill 319 filed by Senator Anna Vitarte, and we urge the members of the committee to pass this bill without any amendments that water it down. That's what we're very concerned with here. Constitutional carry is simple. If you can legally possess a handgun in the state of Georgia, you should be able to legally carry that handgun without any permission slip. Georgia is lagging behind 21 other states, as has been mentioned a few times tonight. They have constitutional carry laws on the books already. Even northeastern states like Vermont, Maine, and New Hampshire. 5 states, including Tennessee and Texas, passed this legislation last year. And constitutional carry is currently being considered in Alabama and Florida, basically all these states that surround Georgia. The right to keep and bear arms is as clear as day in the Second Amendment. And it is far past time for Georgia law to cease infringing on this right and instead protect it. Constitutional carry states continually rank among the safest in the country, with Maine, a constitutional carry state, ranking number 1 in everything you can Google pretty much. I want to reiterate, the National Association for Gun Rights supports Senate Bill 319 as written and is opposed to any amendments that would water down the bill. We will update the citizens of Georgia on your actions. Thank you.
All right, thank you, Ms. Young. Any questions? We have Senator Jones.
I just return back to the question about the, and I understand you're not a First Amendment expert, but how do you have that on First Amendment issues? You have restrictions which grow every day, and we're going to be debating those soon, but the Second Amendment should have no restriction, just a permit restriction. But you have First Amendment permit restrictions.
I don't believe we have to get permits for the First Amendment either.
Yeah. Do you ever think you have to get a permit to have a parade or have speeches?
Are you asking me if I have to have a permit to
Yeah.
hold parades in the city?
Yeah.
Well, if that's a first, I mean, I could talk about, whether my personal feelings about First Amendment infringements or something that's reasonable, but that depends on whether you believe and whether the law believes that that is indeed your right. That's not saying that the right is able to have infringements on it.
Are there infringements that we have on other rights that may exist?
In our country?
Yes.
Yes, sir. We have plenty of infringements on the Second Amendment as well, unfortunately.
But I'm just asking about the one infringement, the small infringement of just having a permit. Why is that so bad?
Sure, I would disagree that it's small, and I'll tell you why. The reason why I believe it's not small is because it's so bad. So you have people like myself so I live in Texas now. I was born and raised in Tunnel Hill, Georgia. I went to the Capitol all the time doing my job without a permit, not able to carry a gun, and before I was old enough to go get a license, but old enough to possess a gun, I also could not carry a gun to protect myself. That is huge for people, especially people who may not be as physically strong as others. I just happen to believe that you shouldn't have to be a martial arts expert to defend yourself. We have something called the Great Equalizer, and thankfully we have the Second Amendment to protect that right.
So would your position be that basically what you're saying is you shouldn't have to have paperwork to exercise your right under the Second Amendment?
I shouldn't have to have a permit from the government in order to carry my firearm that I legally own. Yes.
And to get that permit, you usually have to show like identification or something?
To get a license, yes, you do have to show identification. You have to go under fingerprinting, all kinds of stuff, really. You have to pay a fee. Depending on the state, you have to do training. It depends, though.
So identification is key to getting a permit. Has your organization or any gun rights organization ever taken a position on voter ID laws?
We're a Second Amendment rights organization, so no, we don't really delve too much into voter IDs. I don't know really what that has to do with this bill, but if you want to explain it.
It has to do with, because in reality, what you're really saying is you don't want to show to get a permit is really an identification question, is what it is. They get your ID, they run it, etc. And so I'm just saying, when you're talking about this is our overarching constitutional theory, this is where we are, that theory should branch out to other areas too. But if it doesn't, it doesn't. And you're saying basically it doesn't. Y'all are only concerned about the Second Amendment, and that's fine. I understand.
My organization, yes, we're concerned with the Second Amendment, Amendment rights organization, yes.
Mm-hmm. Okay, no further questions.
Thanks.
Is it Senator Hatchett or Senator Kirkpatrick? Mike 14, Senator Hatchett.
Thank you. With this bill and having to get an ID to have a gun, that was an intriguing question about the right to vote, and I just want to get your, opinion on this. With the right to vote, your right to vote and your right to make sure someone else doesn't vote 2 or 3 times is equally as important, correct?
As equally as important as the Second Amendment?
No. I'm saying like your right to vote versus your right to make sure that one person doesn't vote 4 times. Those are both equally important when you're talking about voting rights.
Yes, I think I would personally say that. Again, we're not really a voting rights organization.
Well, okay,
but
then
yeah, I see what you're saying.
Yeah,
I mean, it would mess with the system.
Okay, but I'm saying, but then does it infringe on your right to bear arms if someone else has 2 or 3 guns?
Absolutely not. In fact, it might help it if they need to defend me.
Thank you.
Any other questions? All right, thank you, Ms. Young. Next, we have Lizzie Stallman with the Temple.
I'm so glad I don't have to stand behind a podium.
Yeah, we lost our podium we used to have. I'm not sure
thrilled.
why.
You wouldn't be able to see me.
Well, good evening.
Good evening. I'll try and be brief, but I've cut this from 4 minutes. I'm Lizzie Stallman. I have been a leader for 6 years in the Rothschild Social Justice Institute at the Temple, where well-being and safety are sacred and firearms are not permitted. A little history lesson, and this continues to perplex me. In the almost a decade that I've been down here with one organization or another trying to be a voice of reason for gun laws, when arguing for passage of HB 60, known as the Guns Everywhere Law in 2014, and later HB 280, Campus Carry, among others, John Monroe, Jerry Henry, and their Georgia Carry legislative allies have always espoused this mantra: what distinguishes a good guy with a gun from a bad guy with a gun is a carry permit. Even I think Mr. Weaver, if he's still here, I don't know if he's still here, would agree. He was much younger when he was on the House side arguing against what I was for. The first constitutional carry bill was introduced by then freshman Rep. Heath Clark in 2015 and didn't even get a hearing. I even remember one Republican representative telling me they were just letting him get his feet wet. Since then, there have been bills every session never to get a hearing. In fact, during the first 3 years of the Kemp administration, bills have been on the table, but no hearings. What's changed? A recent UGA Go Dogs poll showed that 7 out of 10 oppose permitless carry. As Senator Parent pointed out, the Georgia Council of Probate Judges gave the number for 2020, which is the last year they have statistics for so far. 5292 denials. Perhaps COVID resulted in widespread unemployment, desperate people, and fear of them. But that's almost double previous year's denials. Those denied, mostly due to criminal or domestic violence convictions, are probably carrying without a permit. But right now, if one of them is stopped by law enforcement, they can be flagged immediately. The officer is the gatekeeper. Changing license holder to lawful weapons carrier will require time-consuming work by the officer to assure the carrier is able to lawfully carry. Without a permit requirement, how does the officer tell whether he's a good guy or a bad guy? And what about the officer's safety? What's the real motivation here?
If you'll please try to
I will
wrap it up.
Yeah, I will do my best. Loyalty to a governor who's in a tough primary race, or maybe to Remington, the newest manufacturer to relocate to Georgia. You represent your own constituencies and try to anticipate their needs, but the proliferation of firearms in this state has resulted in at least weekly deaths of innocent children. Instead of allowing for virtually unlimited carry of guns, be loyal to the children and advocate for required training, safe storage, and red flag laws, just to name a few. Please let your conscience guide you, not the misguided direction of the gun lobby. Thank you so much for allowing me to go over.
Thank you. Any questions for Ms. Stallman? All right, thank you. Next, we have Fallon McClure with Working Families Party. Good evening.
Good evening. How are y'all doing today?
Good, about you?
I'm doing well, thank
Good.
you. So my name is Fallon McClure. I am the Organizing Elections Director for the Working Families Party in the Southeast region. And I'm a proud Georgia native, and I am in Senator Rhett's district in Powder Springs. So the Working Families Party is a multiracial, grassroots political party that recruits and trains electeds of the next generation to be leaders. And we've been at the forefront of movement to elect champions for working families up and down the ballot across the country. But today we're here on behalf of working families, members, and voters. Our members and voters at large have indicated that they do not want this legislation. Voters want investment in communities. Georgians do not want these proposals. They want investment in their communities that promote public safety. According to the AJC's pre-legislative survey conducted by the SPIA Survey Research Center, 60% of all Georgians disagree that adults should be allowed to carry concealed handguns in public without a license. This includes a decisive 54% of Republicans, 52.5% of white voters, and 79% of black voters. So the numbers are clear that Georgians overwhelmingly reject these efforts. Additionally, there's a national spike in gun violence, although it should not be conflated with the rise in crime overall. In Atlanta and other cities, other categories of crime are actually lower than 2019 numbers when we're talking about things such as rape, robbery, larceny, burglary. However, there is a spike in gun violence. And unfortunately, black people are about 10 times as likely as white people to die by firearm homicide. Additionally, the pandemic has exacerbated some of these conditions. Because of the disproportionate impact of city gun violence on black communities. To contain the virus, thousands of businesses temporarily closed, and many of those closures turned permanent. These layoffs disproportionately affected black communities because they are overrepresented in jobs that cannot be done remotely. So I'll just finish up. Across race, gender, and political lines, Georgians broadly oppose proposals that would allow individuals to carry firearms without a license. Instead, we are looking for policies that would invest in community.
Thank you, Ms. McClure. I thought somebody might have a question. You up for election this year? She is a constituent. Senator Rhett.
Thank you, Mr. Chairman. I think we all are. Thank you for coming. I appreciate it.
Mm-hmm.
But I think you and I both agree that there's a question mark whether or not this bill truly supports public safety.
Correct.
And I think there's probably a better way to approach things than to, I served in Air Force, I served in Kansas, so I've been through Dodge City and those type of places. But but do you have any suggestions at all or any thoughts that you might want to convey about this bill?
Yes, typically what we see is investment in community-based solutions tend to reduce the amount of gun violence, whether that's on the front end for education and opportunities, all the way through programs that support people that are returning to society that cut back on recidivism. So essentially just having opportunity, and that can come in various ways, those can help reduce the gun violence.
All right, no other questions. Thank you so much.
Thank you.
Next, we have Thomas Weaver, private citizen. I like that you always write that. So read it.
I always
Good
do,
evening.
Mr. Chairman. Thank you for recognizing me to speak on second occasion, and I just wanted to submit proponent testimony and approbation of the legislative efforts by your peer, Senator Adam Vitarte, in regards to Senate Bill 319. It's good that he's brought this legislation. It's high tide that it becomes law, and I thank the committee for the committee's consideration and hopefully favorable consideration and recommendation of this legislative measure.
Thank you, Mr. Weaver. Somehow that invoked a question. Dr. Watson.
Thank you, Ms. Weaver. I certainly appreciate your wealth of knowledge that you come to this committee with. So, thank you. Number one. Number two is the question. In our folder here, it says, and I think that maybe one of the questions related to this. Would it change who gets guns when it comes to background checks and who can possess guns relating to felony convictions or pending criminal proceedings or drug convictions or disqualifying convictions, or whether you've been in the mental hospital or drug or alcohol treatment center within the past 5 years or been involuntarily committed to a mental hospital?
Senator Watson, thank you first for the question, and thank you also for giving me an opportunity to respond. Before I answer you, I'd like to share on record, and for the benefit of everyone in attendance, I'm not an attorney at law. I can't provide professional legal counsel. For professional legal counsel, please consult with a trusted attorney. However, I give you my personal opinion on it. No, I think the answer to your question is no. What Senator Anna Vitarte testified to in his speech, and when he was being drilled by the minority opposition, what he tried to convey, and in approbation of your question, is no. No. United States federal law remains the same. Individuals who are statutorily disqualified under federal law or who are also or may be disqualified under Georgia Code Section 16-11-131 will continue to remain prohibited. It does not change one iota on any of that, any regard in that. If you're disqualified under federal or state law, you continue to remain disqualified under this legislation.
What was that? The OCGA
16-11-131, possession of a firearm by a convicted felon or felony first offender.
Gotcha. Thank you.
Would you like to know the federal code section?
Sure. I may not, but I bet there may be others up here.
18 U.S.C. 922 G and N.
You want to repeat that one more time?
18 U.S.C. 922 G and also N.
Okay.
The way the federal government, way the Congress writes their laws is a little bit different than how we write ours, as far as how they put it in there.
Thank you. Can I have a follow-up, Mr.
Sure.
Chairman? So that has to do with felony convictions. What about those, involuntarily committed in a mental hospital or who have drug convictions, other disqualifying convictions? Is that?
If an individual were to approach a federal firearms licensee who has been issued an FFL from the ATF to conduct business in that regard, if they were to attempt to purchase a firearm from that dealer is required under federal law to contact the FBI NICS, and NICS would respond if that information is on file that individual is disqualified, and that would result in a denial.
So just help me. I know you're not a lawyer,
Right.
but you do talk technically a little bit, and I'm a physician, so you're going to sort of dumb it down a little bit, maybe. So what you were saying is that they would do a background check, run through the FBI background check.
That's right.
And that because of those issues, what I had mentioned, the drug convictions, felony convictions, other disqualifying, involuntary commissions, and mental health, and so forth.
If a random stranger were to walk into a federal firearm licensee's premise, as we're talking right now, and we're desirous to purchase a firearm, that dealer cannot transfer that firearm to that prospective purchaser until the dealer completes that check under federal law. If that check results in an affirmation that the prospective purchaser is statutorily disqualified under federal law, the dealer cannot transfer that firearm.
I think that was a yes, right? I appreciate that.
Right.
Thank you.
Any other questions for Mr. Weaver? All right, thank you. Next, we have April Ross with the Georgia Commission on Family Violence. Good evening.
Thank you, Senator Strickland, Mr. Chairman. I am here on behalf of the Georgia Commission on Family Violence just to share a little information with the committee and offer a proposal. Georgia's made great progress with respect to domestic violence and towards our collective goal of reducing offenders of domestic violence and increasing safety for victims. But I do want to point out a few things. Addressing access of firearms by abusers is essential to protecting victims of abuse. Our research suggests that the risk of homicide increases when a violent, intimate partner has access to firearms, and firearms involved assaults are 12 times more likely to result in deaths than assaults which do not involve firearms. So, and then additionally, there's a 500% increase in the risk of homicide when an abusive intimate partner has access to a gun. Oh, excuse me. Take a chance to take this off for a second. Both best practice nationally and recognized experts in the family violence field view firearms access as the key impact issue, which, if addressed, would dramatically reduce the risk of domestic violence-related deaths. Abusers that access firearms also have a greater likelihood, well, in family violence-related fatalities, the people that are impacted are not only the abusers and the victims. First responders and bystanders are also often impacted. In fact, a 2018 Department of Justice study of law enforcement line of duty fatalities confirmed that domestic violence incidents represented the highest number of fatal types of calls for service, accounting for 29% of deaths which occurred in the line of duty between 2010 and 2016, and 100% of those deaths were by firearm. In our state, abusers accessing or with access to firearms who are experiencing mental health crises are also a significant risk for attempted murder-suicides. Between 2019 and 2021, there were 92 murder-suicide incidents in Georgia, accounting for 181 fatalities. 90% of those deaths were by firearm. We, as the Commission on Family Violence, collect and try to warehouse the data on family violence fatalities and family violence incidents in Georgia. What we'd like to ask this committee and the author of the bill to do is take a consideration to propose amendments to this bill that might provide possible safeguards provisions for victims of family violence and intimate partner violence. And one way to do that is to potentially look at taking steps to include in the code section something that addresses the abusers of intimate partner violence, and something that would bring our state more aligned with what the federal law already says in code section 18 USC 922G, as we just heard. So that's what I would ask, is that the committee take that into account and be willing to consider some provisions that may safeguard and protect victims of violence. Thank you.
All right, thank you, Ms. Ross. We have a question, Senator Parent.
Thank you, Mr. Chairman. Thank you, Ms. Ross. What was that federal code citation again?
Oh, 18 USC 922G.
922G. So the facts that you're giving us demonstrate that more guns in the more hands of more people will be dangerous for domestic violence victims.
Yes, in domestic violence related incidents, it is factually true and proven by statistic, not just in our state, but nationally, that when there is a presence of a firearm in an abusive situation, it increases the risk of a fatality by 500%, and it is irrespective of who owns the firearm. And in fact, I'll also add that oftentimes when victims of domestic violence have used firearms to protect themselves or to take action against an abuser, it often results in them being convicted of felony murder.
So you have not found that women owning guns lessened their risk of being harmed?
That has not been what the statistics show.
Thank you.
Senator Rhett.
Thank you, Mr. Chairman. How you doing, Ms. Ross?
I'm doing well, thank you.
We've worked together on legislation pertaining to, your circumstances. But I just want to ask, I thank you for coming down, but I just want to ask you, do you see this legislation at all, having any type of a positive effect on your movement and what you're trying to do?
The commission isn't taking a position on the bill. We're simply just asking for provisions to be considered to safeguard victims. So we do know again that the statistics in Georgia do show, that firearms in abusive situations certainly increase the risk of fatality. And they increase that risk for the abuser, who could die in a murder-suicide incident. They increase the risk certainly for the victim, who could be killed by his or her abuser, and certainly, again, bystanders as well, including our first responders.
If you have any suggestions, feel free to submit it to the Minority Caucus here, and we'll work with you on it.
Certainly.
Thank you.
Senator Kirkpatrick.
Hi, Ms. Ross. Thank you so much for being with us today. I'm a little confused by the federal code section that you quoted, 18 USC 922G, because the way I'm reading it, it sounds like anybody convicted of a felony and anyone subject to a domestic violence protective order is already banned.
Correct. But Georgia has not so far passed a law to bring our state law in alignment with that. And so local law enforcement officers can't enforce federal law. They can only enforce state law. And so while we're asking for a provision, and this would help to bring us a little more in alignment and allow local law enforcement officers to enforce that.
Any other questions for Ms. Ross? All right, thank you. I skipped over somebody earlier. I apologize. Bentley Hudgens, signed to speak. Good evening.
Good evening.
Sorry I skipped over you. I had you checked off, but then one of my colleagues reminded me he hadn't spoken yet.
So hey everybody, my name is Bentley Hudgens. Y'all might have seen me around the Capitol. I'm actually from Henry County, but I came here today to urge you to vote no on this bill. So I've heard a lot about abstracts. I've heard a lot about theoretical ideas of freedom, but I want to talk to you from a place of personal experience. I was a lead organizer for the Stop Asian Hate rally following the ruthless racist attacks against Asian women and their colleagues working in the service industry. Thousands of our community members gathered right outside of these doors and marched in the streets to demonstrate for the urgent need for safety and peace in our communities. As it has been said several times today, more guns does not equal more safety. More guns equals more bullets in bodies that are then buried in the ground. This summer, my friend Josh, right here, who is gay and of Asian descent, was attacked and found unconscious on the Lindbergh train tracks. while I was in this committee room, his partner Colin sent me a video of him learning how to walk. He can't even remember a lot of his life beforehand, and his partner asked me to come up here today and to testify against this bill. I quote, "We almost lost him to blunt force trauma. Had it been a gun, we wouldn't be watching him recover today." It has become normalized for our children to fear that one day their own school will be another Columbine, Sandy Hook, Red Lake, Virginia Tech, or any of the other schools in Georgia that have faced gun violence. Langston Hughes High School in Fairburn, Georgia, Savannah State multiple times, Mount Zion High School, Georgia State University, Miller Grove High School. When I was at Mercer, I lost 2 people to gun violence in Macon. One of them on my 22nd birthday, my friend Randall was shot in the back after he was kidnapped. Another one was my colleague Jabri Bryant, who played on the basketball team. He was fatally shot at the gas station that I went to almost every day. Gun violence is a public health epidemic. I'll end with this. Why are you and your colleagues making it easier to kill, harder to vote, and even harder for our teachers to do their jobs? Why? The way to decrease violence is to fully fund education, to look at better health care, to increase the minimum wage, and address economic insecurity, not making it easier to carry guns without a permit. So, I'll close with this. I urge you to vote no on this bill and move forward and consider ways that we can actually reduce harm in our communities. Thank you.
Thank you, Mr. Hudgens. Any questions for him? All right, thank you for being here.
Thank you.
Next, we have Louis Estrada with Georgia's Second Amendment.
Thank you, Mr. Chairman.
Good evening.
Can you hear me? Yes. And committee members, it's really an honor to be with you today. My name is Luis Estrada. I'm a member of the board of directors of Georgia's Second Amendment, formerly known as GeorgiaCarry.org. And I have to tell you, I have a very personal story as well. I was born in El Salvador, and about 40 years ago, my sister and 3 other female members of my family were shot down on the street by a gang of criminals. There was absolutely no resort for them. They died. Well, my sister died of a gunshot in the head. My other family members were wounded as well, taken to the hospital. I was the one who went to recognize the body of my sister. Again, it was a very bad experience, but that basically gave me a complete, full appreciation for the freedoms that we have in this country. One of the problems in my native country, El Salvador, is that no private individual can own a firearm. It's totally impossible and very difficult for anybody to defend themselves. So the only people who have firearms are gangs, criminals, MS-13, for example. I have a very hard time thinking of a MS-13 member going to a courthouse trying to get a permit to carry a gun. That doesn't happen. That's a fallacy. And we are trying to punish law-abiding citizens. They are not the ones who commit crimes. In fact, all kinds of statistics show that a law-abiding citizen that carries a gun is typically a lot more law-abiding than even law enforcement officers. That's a fact. Now, there's a lot of statistics going around. There is a very nice guy, Dr. John.
The alarm was supposed to go off now, but it didn't. So there it
Okay.
goes. Sorry.
Okay.
We had it.
So anyway,
I'll let you wrap up.
there is a national firearm survey that came out last year that basically surveyed 54,000 people and found that on average 1.67 million defenses happen with a firearm, and in less than 20% of those a shot is ever fired. Just the presence of the firearm have saved lives. So this is just my personal experience, and thank you for your time and your attention.
All right. Thank you, Mr. Estrada. Any questions for him? All right. Thank you. I said we had a hard stop at 6, but we are near the end of our list of speakers. So unless somebody has some objection, we can wrap up. You got to be leave by 6:20. Okay. Sam Olens. Good evening.
Thank you, Mr. Chairman. I too live in Senator Rhett's district. Yell at me later, but I appreciate his service as well as the service of all the other members of this committee and legislature. I clearly get what you do on an annual basis rather than just during the session. So right now under Georgia law, as noted in Senate Bill 319, Section 7, page 12, if you're the local high school or the local college, guns are not permitted in sports events. It's overtly in the law now. What it doesn't cover is other major sporting events. So schools are protected, colleges are protected, other major sporting events aren't protected. So what I'm requesting, and I have the language, I could certainly give it to Mark, it's one phrase, is that a new section B8, which is found on page 9, that would literally say, on properties owned or managed by the Georgia World Congress Center Authority. And we all know that there are a lot of major sporting events at the Georgia World Congress Center Authority. So I'm simply suggesting that many major sporting events, like those sporting events at schools and colleges, be expanded to include those events at the Georgia World Congress Center. That is the sum total of my request. I'll be happy to give it to Ledge Council. It's about 10 words, and it just adds major sporting, it just adds those events at the Georgia World Congress Center. Thank you.
So just to be clear, though, it's not your position that this bill expands any rights to as far as where guns can be carried. You're asking for the existing law to be amended while we're in this code section, in essence?
Yes, Mr. Chairman.
And doesn't the existing law, as interpreted, allow sports venues and other venues in our state that has security that checks for weapons, whether someone's got a concealed carry permit or not, allows them to prohibit weapons on those premises?
That gets into a really gray area because, as you may recall, the professional sporting events that occur at the Georgia World Congress Center are there due to what's called a usufruct. And a usufruct is different than the language that is found in Georgia law, and specifically Senate Bill 319 now. If it were a regular long-term private lease, as the chairman was suggesting, I wouldn't be here. But because it's a usufruct as compared to a regular long-term lease, the law is not clear in that regard, and that's why I'm here.
And that's dealing with the private property rights, saying a private entity, if they are private, if they have security, could prohibit guns, correct? But there's also another provision that talks about the existing law, government buildings as defined. And so if any facilities you're referencing are defined as government buildings, they also can still prohibit firearms if they have security at events. Is that right?
Yes, sir.
Okay.
But once again, I'm looking to remove any ambiguity in that regard.
Okay. You have a question from your constituent.
Senator Rett. Thank you, Mr. Chairman.
He's not supposed to ask me questions.
He kept changing whether or not he's going to ask you, but he decided to. Go ahead.
Well, I just wanted to see if you had any other thoughts you wanted to share about this bill beyond the 2 minutes that you still have time.
Candidly, Senator Rett, my job is to represent my client who has many major sports events at the Georgia World Congress Center. Just so we're clear, my client is not the state of Georgia. My client is that entity that has all those major sporting events at the World Congress Center. And I think it would be inappropriate when I'm representing my client to speak on other issues.
Thank you.
Thank you.
You want to ask him? You have a question from Senator Kennedy?
Yeah, thank you, Mr. Owens. Just one question. The language you're suggesting, did you talk to Senator Anna Batarte about this?
No, I did not. I did talk to the chairman before, and I apologize if I should have it. Candidly, the scope of his bill is totally different than the scope of my proposed amendment.
Sure.
If my proposed amendment related to what Senator Anna Batarte is seeking was Senate Bill 319, I certainly would have overtly done that.
Okay, thank you.
It's a function of it's within the statutory construct.
I'm not being critical, just asking.
That's a very fair question. Thank you.
Any other questions for Mr. Olens? All right, thank you.
Thank you.
That is everyone that signed up to be heard on the bill this evening. What's the pleasure of the committee? Senator Hatchett, your mic 14.
Mr. Chairman, I make a motion to pass.
We have a motion to pass from Senator Hatchett, Senate Bill 319, LC 280017. Do we have a second?
Second.
We have a second from Senator Kennedy. Do we have any amendments?
I'll offer.
All right, Senator Parent.
I would like to offer the amendment just given to our esteemed legislative counsel by former Attorney General Sam Olens. But I'd have to have legislative counsel read it back out and put it in the appropriate portion of the bill, Mr. Chairman.
I'm going to recognize legislative counsel.
Thank you, Mr. Chairman. The substance of the amendment would require on line 200 striking or deleting the word "or." Then on line, on line 203, deleting the period at the end of the line and replacing it with a semicolon and the word "and." Then after line 203, inserting a paragraph number 8, which would read, "on properties owned or managed by the Georgia World Congress Center Authority," period.
Does everybody understand the amendment as offered? Do we have a second for the amendment before we get into further discussion? Second for Senator Jones. Discussion on the amendment. Senator Tillery.
Thank you, Mr. Chairman. Does the author of the bill have any comments on the amendment?
If I could see a copy of the amendment.
Have you seen the amendment?
No, sir. No, Mr. Chairman.
Do you have a copy you can hand to him? While you're looking at that, the concern that I have, and I'm just offering this in the discussion, is you are talking about an area that, as Mr. Olens mentions, outside of the context of this bill. Now, we are in this code section, but is a different provision that's not been discussed anywhere else tonight about whether or not to change the current state of the law when it comes to where you can and cannot carry firearms. And so I think we have to exercise caution if we're going to do this. This is not something that has been vetted by this committee. So that's just my thoughts on it. Other committee members may have thoughts. Do you have any comments on the?
Yeah, I just think at this time, Mr. Chairman, that I don't accept the amendment. I think it needs to be potentially a separate bill and a separate discussion for another day.
Okay. Do you have any other questions, Senator Tillery?
That was the question. I wanted to know the desire of the author.
Yeah. Is there any discussion on the amendment from the committee? Are we having an amendment that's been seconded on the table? All those in favor of the amendment, please raise your hand. We have 3. All opposed? So we have 6 opposed. The amendment fails. Any other amendments? Any discussion on the motion? All right, all those in favor of the motion do pass. Please raise your hand. 5 opposed. 3. The bill passes. 6. Sorry, I miscounted. 6. It's late. All right, you are on to rules. And with that, we are adjourned.